Good morning, everybody. This is Omar Serrato with the Tilted Lawyer podcast, and we are here to give you not a rundown, but look, the Sarah Boone trial is about to wrap up. They should be doing closing arguments at some point this afternoon. They have both rested. It was an extremely quick, fast, short, to the point trial. And to that regard, I think there's an element of surprise in that. I've heard others, as Dominic is over there hacking up a lung, I've heard others give the opinion that, the 3-week estimate was mostly because they thought that Boone was going to be pro per. Pro per trials take a little bit longer, but they just zipped through the evidence. But, fair enough, because there wasn't a whole lot of disputes. I mean, we all know what happened. She trapped her boyfriend in a suitcase and left him in there to die. There's not any dispute as to how George lost his life. There was all of these pretrial motions about how to interpret what it is that we know related to the battered spouse syndrome and all of that, which is essentially a self-defense defense put on by James Owens and Sarah Boone. I'm going to give you my honest opinions of what I think about these attorneys. I'm going to give you my thoughts about who I think is winning and what to expect on closing arguments this afternoon. So you're going to want to stick around. It's going to be a good one.
Whatever you might be going through and wherever you might be, this is Omar Serrato with the Tilted Lawyer podcast. I'm here to take your mind off of things. Yes, I'm an attorney. No, I'm not giving you legal advice. We're going to sit and talk like people, as these are the candid thoughts of one practicing attorney, and it's after hours. So have a seat. Feel free to have a drink and join me. Let's get started.
So, on Tuesday, I believe it was, I live streamed Sarah Boone's testimony. Look, there's been a lot of witnesses in the case, and they were basically contextual witnesses. There wasn't a whole lot of dispute. Certain people, neighbors, got on the stand to say their thoughts and impressions of the couple and what they heard. They heard a sound. It may or may not have been the sound of a suitcase falling down the stairs or some other domestic violence altercation. There's been a battle of the experts that doesn't really give us too much information. Owens put on an expert that said that Sarah suffered from battered spouse syndrome, and they went through a great deal of details highlighting why that is and what it encumbers and what's the symptoms and what is the ramifications and blah, blah, blah. And then the prosecution puts on their own expert that basically said, a full day of testimony, and at the end of all of that, it was like, well, she might have had battered spouse syndrome. So there was a lot of haggling back and forth about whether or not the prosecution's expert witness was actually prepared, if she had read the previous notes, if she had given her a full-on examination, whether or not how she formed certain opinions, and if she had certain opinions, why wasn't it disclosed at deposition? And they went through that whole exercise, all of it to say that, she could have had battered spouse syndrome. Would battered spouse syndrome cause somebody to do what Sarah Boone did? It might have. Would it cause somebody to be in fear of imminent threat upon some kind of a verbal threat? It may have. Would it cause blah, blah, blah? It may, which is to say that I don't know if she had battered spouse. She might have. But what they did diagnose her with was, it's not even really relevant, but they made reference to other possible diagnoses that she could have had. They'd made reference to adjustment disorder, and she thought that was probably the result of her 4-year incarceration in county jail. She had made an opinion, which I fully agree with, that Sarah Boone had narcissistic traits. What narcissistic traits? Well, she has a propensity for grandiosity. And then she went on to say, well, there's a lot of people that have narcissistic traits. It doesn't mean that they're necessarily a narcissist. I think the trouble with this case, it's not even really the trouble with this case, but the trouble in evaluating this case is all of you, if you're listening to this live stream, have formed an opinion of Sarah Boone over the course of 4 years. You know her the same way that I know her, which is she is that funny lady down in Florida who went through 8 attorneys, some of which she fired, some of which she had their attorney try to withdraw from the case. She made a 1920s style advertisement for any attorney wanting to jump on a nationally televised trial, presume to represent her, because the state was not going to provide her with an attorney. James Owens comes to the rescue. We made some mention of that. And I got to tell you, for whatever you think about Sarah Boone, for whatever you think about Owens and how he may have underperformed in the suppression motion, which to me wasn't that big of a deal, he has done a brilliant job defending Boone in this case on a month's notice. I've thought for a long time now that the prosecution has fallen flat in critical areas that has left the door open for the potential for an acquittal. Now, examining Boone's testimony is going to be dispositive of this case. I don't think that you're going to have a clear winner when it comes to the experts, because they weren't really, not either one of them said definitively that she didn't have battered spouse syndrome. It was a possibility, and one of them said that she straight out had it. So what do you do with that? It's kind of it's a big nothing. All of the other witnesses, the law enforcement testimony, the neighbor testimony, they seemingly point to some kind of an altercation. We have gotten to prior instances of bad acts on the part of Boone, on the part of Torres. It's pretty undeniable that Sarah Boone, on multiple occasions, got her ass kicked by George, given those injuries. Now, you could call it mutual combat, and you wouldn't be wrong in calling it mutual combat. I mean, one of the questions that I had early on in the case was, how was the prosecution going to use the size differential between the two? Knowing that we were, 4 years ago, Sarah Boone claimed to have been 98 pounds or something like that. George was 103, dripping wet, 5'3", 103, a small person. They were basically the same size. There was a portion of testimony that the prosecution, I thought it was a big mistake. And I don't know why he did it, because I don't think much came of it. But if anything came of it, it would have been the fact that because Sarah Boone is of similar size to George, maybe her standing next to the suitcase, fiddling around with it, would give the jurors some kind of indication that, yeah, he could certainly fit in there. But my pushback on that is they already knew that. They knew that she was drunk. They knew that he was drunk. They knew that they were drinking. They knew that they got into these altercations. They knew that he was in the suitcase, is incontroverted. They knew that he died in the suitcase. So what was the point of that? It was this bizarre, I'm going to play back some of the testimony. I'm not going to go through the whole 5-hour testimony of Boone, just the highlights. I, in real time, was reacting to the prosecutor's cross-examination. And let's just say, it's pretty safe to say that had I been, not that I'm the big master cross-examiner or anything, I'm just saying that there was opportunity to rip her to shreds. And he didn't. Why? Now look, he's got a different style than I, for sure. My style on cross-exam is very incendiary. It's very much, I'm going to go into your house and start throwing stuff around and breaking shit and try to tear down your house brick by brick. His style was basically, upon reflecting upon it, he just wanted to argue points and get them in the record so that he can argue the facts on his closing arguments. And basically his argument is going to be tantamount to this. Like, look, battered spouse syndrome is a self-defense theory of the case. And you heard through my cross-examination, Boone on multiple occasions say that she wasn't in fear at a certain point. She literally specifically said at one point, he stopped doing what he was doing. Meaning, even if there was a threat, you have to believe Boone on account of that. She's the only person that is saying that, because the evidence that we have on video is the guy was begging for mercy because he couldn't breathe. And so Boone herself says at some point he stopped making threats, and she felt so safe that she just, there was an opening in the suitcase, so she thought, and she went to bed and fell asleep. She did say that. She said, at first she said, I just want everybody to know that I'm scared at all times, which I thought was a stupid thing to say. And I gotta imagine that she was probably prepped not to say that, but she thinks she's smarter than everybody. And so I just want everybody to know that I'm always afraid. It's like, all right, Sarah, you're always afraid. Explain. It puts her in an immediate hole. And then she goes on to talk about how she kind of coddles George and is monitoring his moods, giving him activities to do. If he's sad, she said that he was sad. And so they called his daughter together to, I guess, cheer him up. They did puzzles together. They went down to the liquor store and bought like these 1.5 liter bottles of, economy level grade wine. I'm not sure what that was. Mega pints. And they finished off one from the day before and bought a brand new one. So they were properly sloshed. And I'm just not sure why the prosecution harped so heavily on, oh, so you did buy this. And you see this big ass bottle, you drank the whole thing, right? Conceded. It's been well established that she was properly drunk. And I just don't understand what we're wasting time on cross-exam with this for. There was a moment in the cross where he asked her the question, if you were not drunk, would you have done the things that you did to George? And then Boone said, I'm not sure. Which may come back to bite her in the ass, because look, she says at all times she is afraid of George. She's especially afraid of George when he's drinking. And she said that at some point she thought that had he gotten out of the suitcase, he was going to rearrange her face with a baseball bat, with his fist, whatever. There was video of George destroying the television, taking swings at the television, which I'm like, I mean, it's not putting him in the best light, but my fear is that you cannot assume that the jury is going to pick up on the inconsistencies. When you have an inconsistency in the moment, you have to effing capitalize on it, because you can't leave anything to chance. I don't subscribe to this thought process by certain attorneys, whereby, look, I'm just going to do the examination and the evidence will speak for itself. No, do not let the evidence speak for itself. The duty of a lawyer is to marshal the evidence into the light that is best suited for your side. And in those inconsistent moments, he just fell flat. Now, look, my style of litigating is very brash, I would say. It's very cool, but in a heated moment, I make sure that I milk the moments. So at some point he stopped doing what you said he was doing. You said that he stopped doing what he was doing. And you said that what he was doing was threatening your life. And then he stopped threatening your life. And you still left him in the suitcase, correct? You left him in the suitcase. You made a video where you were taunting him and you were telling him, shh, as if to say, just effing die. There was a text message from like the day before or whatever. Oh, we're going to play hide and go seek, and I'm going to get rid of him. What the F did that mean? That would have been the only non-leading question that I would have raised, because I think that their connection needs to be presented to the jury as they're juxtaposed to each other, so we could connect the dots. She already had it in her mind that she wanted to kill this guy, whether it was in her subconscious or not. She literally said, we're going to play hide and seek. I'm going to get rid of the guy. I'm paraphrasing. And then he's locked in a suitcase. She's telling him, shh, just let it happen. This is what it feels like when you choke me. This is what it feels like when you cheat on me. she made reference to, look, she was at some point not in fear. At some point, she wanted him to understand. Do you remember that testimony? I'll play it here in a bit. But she literally said, I just wanted him to understand how I feel. She conjured up thoughts of infidelity because he may or may not have been looking at porn on her phone, which I thought was weird. Hey, Dominic, when you look at porn, do you look at it on your girlfriend's phone?
No.
Now that could be for a lot. What's up, Lauren? That could be for a lot of different reasons. Maybe he doesn't have his own cell phone. I don't know. I know that the two of them, by the uncontroverted facts, they didn't have a whole lot of money. But the idea that she was upset by him looking at porn on her phone, I'm curious about what kind of porn it was. Do we know that for sure? Because I would just like to know what category of pornography he was searching. Because if it was like, I don't know, I feel like the category might be instructive of whether or not it was George or her looking at porn. And it's not even all that relevant, because what she said was she felt that it was cheating for him to look at that, to become sexually aroused without her, I guess, is her theory. And she was at some point angry at that. And so she's angry leading up to the suitcase incident. That is not fear. Fear comes from a different place. Anger is incendiary. Fear is instinctual. And the only instinct that is recorded by her testimony, because she didn't record these threats that she perceived, is her subjective perception that George was cheating on her. Maybe they had some kind of a domestic incident the night before where he maybe choked her. Maybe they were in a rough sex and it went a little bit too far. Maybe he ignored the safe word. Maybe a lot of things. The point is, we're not going to know exactly what happened. We do know that there were prior incidents that's uncontroverted. She got her ass beat 100%. But there was also, as a result of the state's rebuttal evidence, evidence that, look, it was a mutual combat thing sometimes. Sometimes he was at her mercy. Sometimes he might have been categorized as the victim. And it's possible that she was making false allegations to him. At least one occasion, they had mutual complaints against each other. And so, by all accounts, it was a bad relationship. They were bad for each other. They should not have been together. There was no merit to that relationship other than maybe he was the rebound after her divorce. She described him as a real man as opposed to her husband. And I'm not sure what she meant by that, but the way that she would describe George's behavior around her is that maybe he tried to take charge in these artificial ways. She would cook for him and he would say that, I don't care about your food. I just want to F you over the food, or whatever bizarre sexual games that they were playing. And so I don't know what her definitions are as it pertains to men or real men or good or bad relationships. I don't know what her version of domestic violence is, but I can tell you that I feel, as the state's expert testified, that she has narcissistic traits. She didn't go so far as to diagnose him as a narcissist or her as a narcissist. She just said she has this the symptoms of grandiosity. And if you listen to her on the stand, I mean, look, we're literally talking about a guy that suffocated to death, and she's talking about all of her problems and all of this and all of that, and he was this and that, and she's defaming his name posthumously because he can't speak for himself. And you saw him in the video when he would speak for himself. It's like, what in the hell is she talking about? I didn't choke her. I didn't hit her. Look, she's mad because, I forgot what he said he's mad about. He's mad because I was looking at porn or something. He gave some kind of explanation as to what she could have possibly been mad about. And then when he's begging for his life, when he's begging to breathe, when he's begging to be let out because he is becoming asphyxiated, positional asphyxia, I think was what the autopsy report said, and he is going in and out of consciousness, she wants him to understand her. And so the obvious takeaway from the state's perspective and on cross-exam, I just really wish that he would have hammered down, just brought the freaking hammer down on her when she said she was angry because of the porn, because of the cheating, because of the prior whatever. She even talked about the bills. She was talking about the bills. Maybe she was angry that he didn't make more money. Maybe she was angry that he didn't contribute more. Why would you even bring that up in your direct examination? I don't know, but she did. You weren't fearful of George, were you? Isn't it true that you literally said before he got in the suitcase, you were angry at him because you suspected infidelity? Remember all of those other bitches in his phone? Remember when you were talking about that? What were their names? Clarice? I don't remember what the names were. Whatever the names were. You were not afraid of him. You were pissed off. And then you got drunk off your ass, correct? And we all heard the video evidence. We all saw what you said on the video. You weren't fearful when you were saying those things, were you? You were laughing at him. You were taunting him. You were telling him to shh. You were calling him all these names. You were wanting him to understand, right? How angry you were. You were punishing him. You weren't protecting yourself. You were punishing him. And then you fell asleep because you were a dumbass. Objection, argumentative. Fine, I'll withdraw it. You forgot that he was in there because you were too intoxicated to understand. And you fell asleep. And as you fell asleep, he lost his life in the most horrific of ways. Isn't that true? Why the prosecutor did not capitalize on that moment, on that testimony, really upset me in the moment. I was getting, like, literally, I had to do laps. I was bouncing in my chair. I was hyperventilating. There was even one person that had subscribed to the channel. Like, oh, I'm so glad you're focusing on the coverage and I could just focus. And then there's somebody that got, I couldn't listen to it after your emotional responses. Like, I'm sorry. I was just so flabbergasted. I was like, that cannot be the end of the cross. That cannot be the way that he sat on this case for 4 years. This cannot be the way that he is prosecuting Sarah Boone. It can't, but it was. It was, oh, I don't know. So I don't know if they lost the case because I think there is plenty to argue on closing argument to try to fix that and tie together. Look, if you're going to litigate that way and you're just going to let the evidence speak for itself, I guess, then you better perform on closing arguments and tie it all together for the jury. You cannot assume that they're going to connect the dots for you. And so, look, he's probably tried way more cases than I. And so whatever to that, all I'm saying is that it's always helpful to have a moment in court where you can start picking at these inconsistencies and unravel her entire case and have her fall apart involuntarily. And the fact that he missed that moment, I was upset with the prosecutor, Mr. J, in this case. Now, as far as Owens, he might not be Clarence Darrow. He might not be the greatest attorney in the world, but he has done an amazing job of presenting Sarah's case and arguing for the issues he needs to argue for. And he has stretched this battered spouse syndrome theory to its max. Whether or not it sticks. Hey, Teresa, thanks for becoming a new member. We love you. He found a way to take battered spouse syndrome, turn this into a self-defense case. And the reason he did this was, I know everybody was shitting on it, but including myself. But the reality of it is in Florida, when you're charged with second-degree murder, they don't have to prove intent. So it doesn't matter if she didn't mean to. It didn't even matter if she was just simply negligent. But if you turn this into a self-defense, now maybe she has a chance, right? Because if you don't argue battered spouse syndrome, she's not going to be able to make the argument. Her attorneys were not going to be able to make the argument that, well, it was an accident, and so therefore, it would be unreasonable to expect somebody to lock someone in a suitcase and expect that they're not going to be able to breathe, even when they're being told that the person can't breathe, leave them in there, and then, oh, shucks, he's dead the next morning. Yeah, that defense, there's zero chance that was going to work the way that Florida law works for second-degree murder. So battered spouse, as much of an uphill battle as it presented for the defense, they made it work, and it was really their best chance. And the way that the prosecution, I don't want to say that they put on an incompetent case, because it was not incompetent. They did all of the things, right? They made the prima facie case that she's guilty. I just think that they missed so many opportunities to nail her. Nail her. You cannot ignore the element of theater in criminal trials. There's a reason why law tubers are a thing. There's a reason why true crime channels are a thing. There's a reason why thousands of you flock to these trials when they're being live streamed, because there is no theater like it. So you have to be theatrical. You have to have the ability to speak. You have to have charisma. You have to have the ability to capture the hearts and the minds of the jury. And you have to have the instinct that when you have the defendant on the stand making statements that contradict their defense, you have to nail it in. You have to not let it go. You have to ask all the questions. Get objected to. Make the judge mad. Make the defense counsel mad. I don't give a shit. They're not the ones deciding the case. It's the jurors. You have to make it clear in their mind. In that moment, Sarah gave permission for you to nail her ass, and you failed. I don't know if you failed in the respect that you're going to lose the case. I'm just saying that you missed the moment, man. There was an opportunity there where you could have taken a close 1 or 2 point game at halftime and just ran away with it and blew the defense out of the water. And because you didn't, I'm literally put in my title, is Sarah Boone going to walk? Did the defense do enough? In my estimation, the short answer to that is no. Mama Mia asks, what is your opinion how the DV victim juror felt watching the videos, the last videos from yesterday? That has been my fear with this case. Now, look, presumably I'll tell you this. It's harder for the defense to win a case when there's only 6 jurors. Because, look, reasonable doubt is the standard. You need 1. It's better to have 12 jurors to agree with your side than to win over 6. Just the odds are better of a mistrial or an acquittal when you have 12 jurors. It's harder to convince 12 people to agree on the same thing than it is to convince 6. And so there's that. But you have to understand, too, that these jurors, you have to assume, don't know anything about Sarah Boone. Now, believe it or not, as much as we've been following this case over the years, this is not the most high-profile case there is out there. There are plenty of people who have no idea who Sarah Boone is. It's like, how's your YouTube channel doing? Oh, I'm talking about the Sarah Boone. Sarah Boone, who's that? You don't know about Sarah Boone? She's the one that locked her boyfriend in the suitcase. Oh, never heard of it. It sounds interesting. I'll give it a listen. That kind of stuff. There's plenty of people who have no earthly idea who Sarah Boone is, which means they're not going to have the 4-year look back of all of the nonsense that she's put these courts through by changing attorneys and her shenanigans and her stupid motions and her letters to the judge and all of it. So we have a much different view of her. So now you take that knowledge, and then you allow her testimony. And there's a lot of stupid things that she said during her direct exam and even on cross, that if you don't put it in front of the jury, it risks being interpreted many different ways. But one thing that 100% resonated, there was people in the courtroom that said that, look, there was 3 jurors that were physically reacting to the pictures of Sarah Boone's injuries over the multitude of domestic violence instances that were being described in the case. And Sarah Boone's testimony, when she was talking about that, you could say that she was unemotional. You could call her a psychopath. You could call her whatever you want. But if it was connecting with the jurors the way that it seemed like it did, she was saying things like, he took my head and was bashing it into the closet metal bar over and over again. I thought I was going to die. He was choking me and I thought I was going to die. He beat the shit out of me. And she had like this nasty looking black eye. Those images, you can't discount the impact that it had on the jurors. And my fear was that if Mr. J on cross did not hammer her for the inconsistencies when given the opportunity, then the jurors may have been swayed by that and say, because you're taking that and you're hearing their theory of the defense was battered spouse syndrome. She's definitely a battered spouse. And they're not really arguing against the point. They're saying, oh, mutual combat, whatever, but she definitely got her ass kicked. And then you have an expert say that, oh, she would have perceived threats a lot differently than you and I because of battered spouse syndrome. And then the state's expert comes in there and says that, yeah, she might have had battered spouse. So then you're giving them an opportunity to acquit her. Because if it's not obvious to the jurors that she was lying, then they have a prima facie case of battered spouse defense, which may lead to, at worst, an acquittal, maybe a mistrial, but it's difficult. You saw that evidence. You can't ignore the evidence. Now, the videos that came out yesterday where it portrayed George in a different light, it appeared more like he was the victim. What's the takeaway from that? Let's just say that Sarah Boone was beating the shit out of him sometimes. I watched all of you in previous shows when I described the physical description of Boone and George. Cite that, okay, they might have been the same size, but George he's still a man and way stronger than her. You guys assumed that. So if you assume that, you got to assume that the jurors assumed that. And so, which is to say that if you put them in an MMA match 100 times out of 100, George is going to win that fight. And so if we're conceding or admitting that, yeah, it might have been mutual combat, you're not looking at it from the perspective that Sarah was fighting him and making him the victim. She was defending herself, and maybe she was fighting him out of self-defense. What's the alternative? To get her head caved in on the metal bar of a closet? So you might not agree with that narrative. The question is whether or not the jurors agreed with that narrative. I'm not even sure what to make of it. But look, I've done a lot of these domestic violence cases. I've talked to a lot of you. I've spoken to a lot of victims. I 100% believe that he put his hands on her. I also believe that she put her hands on him. I also believe that there's probably occasions where she purposefully provoked him. And vice versa. They were a bad couple for each other. All it takes for an acquittal in this case is a jury of 6 to agree that she was definitely the victim of multiple attacks. And there might have been instances against her, sure, but I mean, one-on-one in a fight, George is going to win every time. That's one of the arguments that the defense made. And that she believed, by virtue of the threats that she testified to, that's the only evidence that we have of it, that if he got out of that suitcase, he was going to kill her. And so therefore she left him in. Now that's the argument. Obviously the retort is, yeah, but then you said he stopped doing that and then he wasn't a threat and then you weren't afraid, you were angry. You weren't afraid, you wanted to teach him a lesson. And so it's not really self-defense, is it? You just killed him. That's the prosecution in a nutshell, what they're going to argue. Let me go over some of the highlights. So Boone testified, the way that she testified was so puzzling to me. Like, she starts talking about her upbringing. I mean, I imagine that was the defense's attempt to try to humanize Sarah. Talks about her being born in Atlanta. She moves to Orlando at a young age. She attended high school at Edgewater, graduated by the age of 18. Good for her. Talks about the love story between Sarah and George, about how they hit it off quickly. That she was surprised that George was interested in her because of her appearance and recent divorce. I wonder if her hair looked like that back then. I'd imagine it did. They related on the topic of divorce. Sarah moved into her own place after marriage. They, for whatever reason, talked about their agreement as to living expenses, which I just thought, what was the point of that? But they talked about it. Then they brought up her going to buy wine and going to the Publix liquor store. I don't understand why either side spent so much time on this. I feel like it could have just been a concession. Look, yeah, she was drunk. You could clearly see in the video she was drunk. I'm not going to argue the point that she was not. She's slurring her words. She's so far gone in that video. You don't need to be an expert to know that. But they all wanted, just for timeline purposes, that morning they buy liquor at the Publix liquor store. I think they said that they walked down there. It was like a 5 minutes from their place. They went to go for liquor and cigarettes. She talked about George calling his daughters because it was going to help boost his mood. She was talking about him like he was a child, which was so bizarre. It was so bizarre. I don't know what the takeaway is, that if you're the defense, it's like she's trying extra hard to manipulate his moods because she doesn't want him to get angry, because when he gets angry and drunk, it puts her life in peril. Maybe that's what they were going with that. When you heard the prosecution cross-examine her regarding that, he described it as she infantilized him, treated him like he was a 3-year-old, a 4-year-old. We're doing puzzles, we're doing activities, we're doing arts and crafts, like the kind of stuff that you would do with a 3 and 4-year-old. There was a discussion about George's family members and activities leading up to the second bottle incident. She discussed calling George's daughters and brother, listing his siblings and their proximity in Florida. She mentions George going to a convenience store and returning after using her car and debit card to buy another bottle of wine. She talks about they were enjoying the day together. It was a happy day. It was a happy day. They were having a good day. She saw pictures and artwork in Sarah's apartment. Majority of work by Sarah and George they were doodling, and they would literally stick them up on the walls like you would a child. That was the testimony. At some point, Sarah Boone talks about them playing hide and seek. She goes to hide in the shower. She recalls feeling intoxicated as they had consumed alcohol throughout the day. She believed her partner would come find her. Now, that was kind of odd because I imagine it's one of the reasons why the prosecution tried to pin her down. And so what are the rules of hide and seek? Because she said that she went to go hide, but then George went to go hide too. She was supposed to be it. So what does it mean? Like, why are you hiding? And like, who was, we had to get through that whole rigmarole. And then she testifies to finding George trying to get into the suitcase. Now, this part, let me make sure my screen is shared. I'm going to share some of this testimony with you. Not all, just the highlights. Where did my screen go? Here it is. She testifies to the moment that George gets in the suitcase. Now, look, this is important because, look, I don't believe that she forcibly put him in the suitcase. I just don't believe she had the physical ability to do that as a 98-pound woman. I just don't. So this is her account of how it happened.
Anyone who has children understands that they grow quickly, and there was a lot of clothes that I needed to go through of my son's, and then also where we just needed to actually go through it and organizing.
You were going to donate it and a bunch of things that you were going to put inside of it.
Correct, yes.
Okay. So it'd been down there a week, so it was already down there.
Yes, George brought it down.
Okay. So you said that you got down there, you're looking for him, you see him sitting into the suitcase.
Yes.
What did you do?
In my head, I said, oh man, we're obviously not going to be going to sleep anytime soon. And
why not? Because he climbed into the suitcase? I didn't understand it when she said it. I don't understand it now. Like her, I used the word incongruous testimony what I meant by that is just her testimony just doesn't make sense. What do you mean he got into the suitcase and, oh man, it's going to be one hell of a night? The hell is that?
I walked over and he was trying to get himself flat, so I couldn't tell that he was in there. And then
Now, let me stop you there. The suitcase, is it the suitcase over here in the
yes,
box? You've seen it? You saw it?
yes,
It's a pretty big suitcase.
yes.
How big is George?
George was my height.
How
And
tall are you?
I'm 5'3".
Okay. And how much did George weigh?
I thought it was 100 pounds.
Okay. And how much did you weigh?
I was 98 pounds.
All right. Do you agree you put on some weight?
Since I've been incarcerated, yes.
Well, at the time, though, y'all were pretty skinny.
Yes,
So from the pictures, it looks like y'all were both pretty thin.
yes,
All right. So because of his thinness, is that how? And he's a small man.
yes,
Okay. So he was able to get in the suitcase on his.
yes.
Did he willingly get in the suitcase?
He was already in there.
Okay. When you got to him, did he see you?
Yes.
All right. Tell us what happened.
I mean, it just I zipped him up. We thought it was funny, and we're joking about how he was, I guess, small enough to fit inside of the suitcase.
All right. So what happened then?
All right, so that's it. So she testifies, he gets in there, and it starts off as this big joke. And it starts off as this big joke, and everybody's laughing and having a good time, and they're joking about how small he is to fit in the suitcase. She zips him up, and then it just kind of shifts. It just kind of shifts. She testifies about zipping him up, thought it was funny. She says she's moving the suitcase around with him inside, and they're both laughing about it. And so, and mind you, this is the only account that we have, because there's no other person to controvert or disagree with this evidence. But then she expresses fear and anger. If she was my witness, and look, and maybe Owens did this, I gotta assume he's a good attorney. He's a really good attorney. I don't know if he's the best attorney, but he's done an amazing job with this case. I just think that Sarah Boone is an idiot. And sometimes your witnesses are who they are, and there's nothing you could do about it. But I'd imagine that when they were prepping for this, we have to explain why she got so mad. We got to explain those statements that are going to come in on the video. This is what you feel when you choke me. This is what you feel when you cheat on me. All of these kinds of, how do we get there? And then she starts describing anger and fear. And if you're going to describe that, there can't ever be a point in your testimony where you're not fearful. It has to be, if you're going to say that you zipped him up and you thought that if you ever let him out, or if you let him out, he was going to kill you, you can't then go on up there and say that, well, then he stopped doing that, and so I just kind of let him alone, made a video, taunted him a little bit, and then went upstairs to fall asleep. That cannot be the way that it comes out. But that's the way it came out. Look, it would have been, I think, logical for a jury to understand that these two combative people were in the midst of an incident. They were in the midst of an incident. And that she thought, whether she was drunk or sober, that if she let him out, he was going to get out of there and whoop her ass. But she said that he stopped doing that at some point. And then on the video, you could see that he stopped doing that because he's begging for his life, basically. And then she just goes up. At some point, it stops being self-defense. And that's what the prosecution is going to hang their hat on in this case. And that is how they're going to get to second-degree murder. If the jury is able to connect those dots. It's a big if. I personally think they will. I just think, like I said, I have disagreements with her cross-examination. But let me just play this portion of the testimony. She talks about expressing fear and anger.
what you were feeling, what your feelings were at the time, and then explain that to the jury. You mentioned, you talked about it before. You said he was in that confined space and it was my chance, but do you want to elaborate on that? Or?
Sure. I want you all to know that the majority of the time, am always afraid and always scared.
All right, well.
That statement pissed me off so bad. I don't know if you guys shared a similar emotion, but when she said that, I was just like, 100%. She wanted to get that in, and she told her attorney that she wanted to say it, and I'm sure the attorney said, just don't say that, and she said it anyway. I just want everybody to know the majority of the time I'm scared and whatever she said. It was just super cringe.
I understand that. Yeah, I understand that.
You could hear his frustration in his voice. I understand. I get it. Meaning, 100%. They talked about this. He didn't want her to say it, and she said it anyway. And now he's whatever. It is what it is.
But would it be fair to say that you had some anger at that point?
I did.
Would it be fair to say that you wanted to tell him off to some degree?
I just wanted, yes, for him to have a better understanding, which was the whole point of the videos and documentation prior.
I wanted him to have a better understanding. Now, that sentence is important because she repeated that to the prosecutor on cross-examination, and that is not self-defense. Because he even got, the prosecutor, he did a good job of this. He established a timeline, and he got her to say that at some point, when he stopped doing that, she says it again, after the fact, after the threat is being extinguished, she wanted him to understand. When you are legitimately defending yourself, there's not many things that you want your attacker to understand. You just want to be safe. Which is to say, this wasn't self-defense. You weren't fearful. As she tried to say as a boilerplate talking point. She wasn't afraid. She wanted him to understand that she was angry, is the takeaway.
And you could tell that he was uncomfortable.
I'm guessing.
And did you want him to feel some uncomfort?
I did.
Okay. Now, at some point, you turned off the video.
Yes.
And then we saw a second video, which was approximately 11 minutes later. And you've seen that video that was played to the jury. It was 22 seconds long.
Yes.
And I don't think you speak in that video. You hear him say Sarah one time.
Yes.
Is that fair to say?
Yes.
So between the 2-minute video and the 22-second video is an 11-minute period.
This 11 minutes is critical because the alleged threat occurred in between these 11 minutes. You see the one video, there's no threats being made. And then you see the other video where there's no threats being made and he's begging for his life. Her testimony is that whatever threats happened were in between those 11 minutes where there is no recording.
Would you tell the jury what happened?
We continued to, speak to one another, and his tone changed, and I knew the tone, and we ended up, arguing back and forth with one another, and it was the things that he was saying very much frightened me, and cursing at me and threatening me. And
did he want you to let him out of the suitcase?
I'm sure so.
Okay. Her testimony, she does this over and over again. These obvious yes answers. Did he want you to let him out of the suitcase? Yeah, obviously he did. You all heard him say, obviously, Sarah can't breathe, let me out. And she's like, I guess, maybe. So she's being disingenuous. She's not helping her case. Look, there's a world where she gives perfect testimony and, it's not this ridiculous sideshow of stupidity. But look, when she says stuff like that, when she can't even admit to her own attorney that he wanted to be let out of the suitcase, how much could we really believe her? I'm really hoping that the jury picks up on that regarding her lack of credibility and just convicts her ass.
Go ahead, tell me.
And it got very heated very quickly, and
No
he
shit.
continued to push on the suitcase. And
Because he wanted to be left out.
my fear was that he was going to break out of the suitcase, knowing that it was a broken suitcase. And his hand started to come through. His hand started to come through this way. And so I shook the suitcase, trying to get his hand to go back in, shaking it.
So this testimony is really important because it led up to the ability to introduce battered spouse syndrome, which we heard from subsequent experts. What they had to get in was some overt act on the part of George that caused her to be in fear. The overt act, they're saying, was his hand coming out of the suitcase coupled with the threats. Hand coming out of the suitcase is not enough, but when you attach the threats to it, now it becomes a overt act where she thought that she was in imminent fear, and that is enough. All that's required is a scintilla of evidence. That was enough to allow them to introduce that. Plus, had the judge not allowed that, you're talking about this would have been appealed and probably successfully overturned. The judge had to let this in. But so that's
And telling him that, please stop doing this, please.
That's why that testimony is getting used. Now, at some point she says, please stop doing this, but then she says at some point it stopped. And that's going to be really, really important.
Please stop doing this to me. Please stop doing this to me.
So his hand actually got out of the suitcase,
Yes,
and you went to the suitcase
yes,
and shook it.
yes.
Did that force his hand to go back in?
No.
So you're shaking it. Were you shaking it to try to get the suitcase, his hand back in?
Yes.
How long did you shake it?
I don't know.
But his hand still out.
Yes.
Was he trying to get out?
Forcefully, yes.
Was he angry at you?
Yes.
Were you in fear?
Always.
If he
Sorry. When she says always like that, I don't want to say that she has a punchable face because it is, we're talking about domestic violence here, and George is living with this lady. But when she says that, it's just so disingenuous and insincere. I'm really hoping that the jury is picking up on this garbage nonsense testimony. I hope.
If he would have gotten out of the suitcase, what would he have done to you?
Like he used to tell me, he probably would have made me unrecognizable, or I would have lost my life.
Did you lose the grip on the suitcase?
Yes.
Where was the bat in relation to the suitcase?
It was leaning up against the dining room table, right there.
How far was the bat from the suitcase?
3 feet, 2 feet.
Was his hand still out of the suitcase?
Yes.
And was he getting out of the suitcase?
He very much was trying, yes.
And so what did you do?
For the split-second reaction that I had, I happened to see that, and I grabbed the baseball bat and was trying to poke his hand to go back in, to please don't break through, please. So I hit his hand.
Did you hit the outside part of his hand?
Now, listen to her describe how she's hitting. I really hope the jury picks up on this. I don't feel like the prosecution did a good enough job of pointing this out. There was literally a bruise on the palm of her hand right here. If you ever play baseball, when you go to the batting cages or you're hitting for a prolonged amount of time, this part of your palm is always bruised and sore. When they took photographs of her hand the day of the incident, there was a big ass bruise that I recognize as that's what happens when you're swinging the bat really hard over and over again. So she wasn't just poking and prodding. She was swinging at his effing hands and doing real damage. pursuant to the autopsy. And so, but her description of it is like, oh, just poking him in there like it was, like whatever, like a broom. It's not consistent. It should go to destroy her credibility. It's incumbent on the prosecution to make sure they make that argument because they didn't do a good enough job on cross.
Yes.
We've seen the photographs of his left hand. Did you cause the bruising there?
I'm guessing yes.
Now, you've seen the bat. It's a youth bat.
Yes, I bought it for my son.
A youth bat is like 29 ounces. Dominic, when's the last time you played ball? What kind of bat do you swing?
I swing a 32.
You would swing a 32. What do you mean a 32? A 32?
Yeah.
Jesus. You couldn't. Never mind. I'm disappointed.
I was going to say a 29 is not much of a youth bat, but
I mean, a 29 is basically a T-ball bat, no? Like a 29, drop 5, 29, 22,
yeah,
drop
right.
7,
Yeah.
maybe. Yeah, that's like a little league bat. So it's not like this heavy thing, but in the hands of a 98-pound person, which is about the size of a child, that would be enough to cause bruising on their hand if you're swinging it with enough force. In other words, it wasn't like a 34-31 or like Dominic swings a 32-29. Jesus. What the hell? Jesus, man. Have you ever considered stepping up to at least a 33?
Too heavy.
Oh my God. I'm disappointed, Dominic. I don't know what to tell you, man. We need to work on your mechanics. All right.
Is this the bat you used?
Yes.
And you said you poked him with it?
Yes, I kind of pushed, I held it with the skinny part here and then
So grip here.
prodded at it, yes.
You grabbed it with both hands here,
Yes,
and then the barrel of the bat, the big part of the bat is here.
correct.
And you thrusted it into this different area suitcase?
I started with his hand in his hand. He was still trying to get out. He was still trying to do that. So I started to push on the suitcase around it, hoping to have his hand retract and go back inside.
Now, the way that she was angry, there's no effing chance she was just poking at him like that. The bruises that I saw, there's no chance that that was just a poke. She took that bat and was full on wailing at it, at that suitcase. That's the only way you're going to get that bruising on her hand and the bruising on George's hands.
You made
All right, so this is her account. I want to, before this video gets too long, I want to jump to some of the areas of cross-examination just because I was so disappointed in how that all went down. I just felt like there were so many missed opportunities on cross. Let me get over here. All right, so this is the moment where the prosecution has an opportunity to really just lay the effing hammer to her perception of events and the reality that is on the video. What I wanted him to do was I wanted him to grill her on, so you made a video here, and then 11 minutes later, there's another video. And we could see what you're saying and what you're doing and how you're talking and the tone of your voice and the tenor and all those things. You're claiming, and you've said it multiple times here, that you're always in fear. Were you in fear when you said, were you in fear when you said, fuck you? Were you in fear when, all of the derogatory things? And it just falls so flat. Now, look, I don't know if it's his theatrical style. I don't know if it's charisma levels. I don't know what it is. But there was such an opportunity here in this moment to get her. And he just failed. Let me make sure I got the right part. Let's go here. And you'll notice, too, when the prosecution asks her, she doesn't know shit. When her attorney asks her stuff, oh, well, it was this and that, and I'm always fearful, blah, 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 whatever. I really hope the jury doesn't buy into this bullshit.
15 seconds is when he begins to get angry, correct?
What 9 minutes?
Between the
What 9 minutes? I was like, between these 9 minutes, here's exhibit A, whatever exhibit was. This is the video that you took then. And then 9 minutes later, you take this other video. And you could hear him on this video. You can hear him on this video. And he's begging for his life. At what point did he get angry between those 9 minutes? Is that what we're going with?
two videos.
And I thought that he was going to show the videos, and he just didn't. I think that his reasoning would have been, oh, we've already seen the videos. No, they need to see it in that context. They need to see it in the context that they want the jury, that she wants the jury to believe that he was this imminent threat. This is the guy that you were afraid of, the guy begging to breathe, begging for air, begging for whatever. And it just, well, you'll see how it comes out.
There's 9 minutes and 14 seconds between the end of 1061 and the beginning of 1062 and 1063. So you got the 2 minute, 3 second video that starts at 11:12:45, correct?
I guess.
Permission to use state 17?
You may.
Traction 2/23/2020, 11:12:45 p.m.
And then he does this whole thing where he's like fumbling around with like the technology, the video. I don't know what this was. There were so many pauses and delays in his cross. It's like it was difficult to put together and follow in the moment. And so, look, I could follow it. I know what he was trying to do. I know what he was going for. And to me, it felt flat because I knew that he didn't get exactly what he wanted. For the jurors, I question about what they really took from this because it was just so disjointed and illogical in his presentation.
Image underscore 10 is about 2 minutes and 3 seconds. Entry 3111.
The parts that I'm fast forwarding through is literally just radio silence. There's nothing. And so everyone just kind of sitting there twiddling their thumbs while he figures out how to get the videos or the slides up. I don't know, but it wasn't effective. Come on, Jay.
23:03 p.m. Your testimony was that after that first video was captured by your phone and you, Mr. Torres began getting angry and trying to push his way out, correct?
Say it one more time, please.
Between these two movies, of which there's about 9 minutes and 14 seconds, Mr. Torres begins to get angry and try and push his way out and get out of the suitcase, correct?
He had been angry on and off throughout the entire day.
Okay. You didn't tell us that earlier. You said it was a wonderful, fun day all day, correct?
That's because I lived.
Now look, what he's going for is an inconsistency. You didn't mention it. You're literally changing your story on the stand right now, but not really. Look, we were having a good day and he got angry. That's the inconsistency that you want to point out? Come on, Jay. Come on.
Okay. But you did not tell us earlier today that he had been angry throughout the day.
Well, to be fair, she didn't. But also to be fair, she kind of did because she was trying to elevate his mood, remember? With the phone calls to the daughter and all that to try to cheer him up, and he was kind of whatever. She did kind of allude to the fact that he was down in the dumps. She did say that. Now, I don't remember if Owens had addressed it on redirect, but my only point is that was not the inconsistency to go after. I know he's pointing it out. It fell flat in its presentation.
And when I say that?
You described your entire day of doing puzzles and arts and crafts and outside by the dartboard, and you said it was a wonderful day and everything was fun until he was in the suitcase. Did you not testify to that earlier today?
I did.
Okay. My specific question between these two movies is, this is when he begins to get angry and trying to push his way out and to get out of the suitcase, correct?
Angry again, yes.
Okay. And he was expressing his anger in what manner? How did he say this?
At which point throughout the day?
Ma'am, you know very well that I'm talking about between these movies. Please answer my question. Between these two movies, how did he express his anger with you?
that I was going to fucking die.
Okay. Now this is happening after he's already told you several times he cannot breathe in the suitcase, correct?
Correct.
And he's been in there for whatever brief amount of time it took you to zip him up, and the laughter stops, and then you go over and begin to film, correct?
Yes.
And you're filming. Your purpose of filming is to kind of teach him a lesson. This is your chance to say something to him when he can't say anything back to you, correct?
No.
Then correct me.
There was no lesson to be learned. It was just I wanted him to try to understand how I felt so maybe he could.
Now, this is key. This might have lost her the case right here. It's subtle, but it may have lost her the case because she's no longer in fear. She wants him to understand. Let me back up a little bit.
Just
Anything correct?
yes.
And it's in the suitcase, correct?
Correct.
And he's been in there for whatever brief amount of time it took you to zip him up, and the laughter stops, and then you go over and begin to film, correct?
Yes.
And you're filming. Your purpose of filming is to kind of teach him a lesson. This is your chance to say something to him when he can't say anything back to you, correct?
No.
No, that's literally what you said on direct.
Then correct me.
There was no lesson to be learned. It was just I wanted him to try to understand how I felt so maybe he could progress in being a better person the next day.
That sounds like a lesson, doesn't it?
So you wanted him to understand how you felt in the past, and that's not teaching a lesson?
I just wanted him to understand.
Okay. All right, and so immediately prior to zipping him up and putting him into the movie, you had been upstairs, correct?
I'm sorry.
Immediately before coming down and zipping him up and then filming the first of the two movies, you had been upstairs in the shower, correct?
Yes.
I'm going to publish what has been labeled as image_1061, which are
All right. So it goes on. It goes on. Listen, it's crucial to Boone's case that at all times during this incident, she's defending herself. And they've been arguing jury instructions all morning. But one of the instructions is, or one of the things that I'd imagine on cross-exam or on closing arguments is going to become a thing is, it's one thing for her to say, okay, she was fearful because she pissed him off. He gets out the suitcase. He's going to whoop her ass. That's one thing. But if at any moment you believe that fear was suspended at any point and at any time, she's no longer defending herself. She's committing an aggravated assault that led to the death of Jorge Torres. We know that he's dead, so this is a murder. If in your deliberations you come to find that it is uncontroverted because she said it on the stand, that at some point he stopped doing what he was doing and she left the zipper open just enough where she thought he could get out, and then she went to bed, I want you to understand that what that means is she was no longer in fear of this guy. She was no longer in fear. And she murdered him. That's it. So, who's winning as we progress to closing? Hopefully we get to closing arguments tonight. I don't know. There's a lot of emotions that they're still fighting about. But who is winning at this point? I think that the prosecution has done enough. I am very fearful of the impact of the images of her injuries related to DV incidents. The testimony of the experts basically conceding the point that she probably has battered spouse syndrome. One says that she does, one says she may. Meaning that she probably does. I don't know. If I was a juror, I'd say, well, she probably does have battered spouse syndrome. And if you believe that she had that, then both of the experts had testified to what would be the ramifications of that. She would have a heightened sense of fear, heightened sense of this and that, whatever. Fine. The prosecution's job then at that point is to say, yeah, but at some point she wasn't fearful because she came up here on the stand and she effing said it. This is not a victim here. There's only one person that lost their life. She killed that man because of her anger, because of her stupidity, because she wanted him to understand. Because she wanted him to understand that she was really angry that he was looking at porn on her cell phone. That she was really angry at the fact that he had all of these other side pieces. Because she wanted him to understand, this is how you feel when you choke me, when you cheat on me, when you this, when you that, whatever. There's some instances of anger over past domestic violence incidences, for sure. Conceded. But at some point, that didn't lead to George's murder. At some point, she knew that she wasn't in danger. At some point, she knew. Not that she knew. At some point, she was not in fear. At some point, she knew. She thought that he could get out anyway. And then she chose to go to bed because she knew that she wasn't in fear. This was not self-defense. This was murder. There's only one logical conclusion in this case, and that she is guilty on all counts. I'm going to ask that you find jurors, find Ms. Boone guilty of the murder of George Torres. His name was Jorge Torres. He had a family, he had daughters, he had family, he had siblings. He had people that loved him. He wasn't a perfect person, but he didn't deserve what he got. But he got what he got because Sarah is who she is. She's a murderer. And it's incumbent on you find people to make the appropriate decision and find her guilty. I'd imagine that that's going to be somewhat what the closing argument resembles. I imagine. I would not be surprised. I would not be surprised if she's acquitted or a hung jury, just because I thought that, look, it's not that the prosecution put on a bad case. He put on an adequate case. I just felt like he missed opportunities to score points. And in a trial of this magnitude, it is upsetting when that happens. I grade the state's performance a C. I would give Owens a B+. It would be an A if he had more witness control, but who's going to control Sarah Boone at this point? She was going to say what she said. So I 100% she's guilty. I believe that she should be found guilty. I believe that she is a narcissist. I believe that she killed that man. Whether or not the jury agrees with me is dependent upon how they view the state's presentation of evidence. And I have concerns. They're going to be going to deliberations, I'd imagine, today. I'm assuming the closing arguments will be this afternoon. I will 100% do a video breaking down the closing arguments. But as of right now, who's winning? I believe it's I believe the state is winning. But if this was like a boxing match, I'd be real nervous because anything could happen in a close fight. And so we'll see. We will see. Folks, I love you all. That I'm going to wrap up today because I know they're going back live in the courtroom right now. You're going to want to, if you got the time, go on ahead and if you're interested in it, watch the closing arguments. If they get there, when we left off earlier this morning, they were still on not pre-trial. They were arguing about jury instructions. So I don't know how much longer that's going to go. I'd imagine they're going to finish with closing arguments today, but they're going to start deliberations, I'm assuming Monday morning, if they're not still wrapped up in closing arguments. I have to imagine that the judge is going to go late just to make sure that we got our closing arguments in. Or one of the things that might happen is that the attorneys might say that, look, why don't we just do closing arguments on Monday? And that way we can start deliberations on Monday afternoon and have all week to deliberate and hopefully have a verdict by Wednesday, Thursday, Friday, whatever. So we'll see. We'll see. But who's winning right now? I'm giving a slight edge to the prosecution. I'm just saying that it should be a lot. It should be a lot. They should be ahead by a lot more than they currently are, is all I'm saying. So with that, I love you all. I'm about to do Family Law After Dark. I'll be joined by guests. I hope you all join me. I'll be talking about all kinds of shenanigans, from user submissions. Some of my moderators wanted me to do some of these cases. It's always a crazy occasion whenever we do Family Law After Dark. So join me over there. Dominic, if you could leave a link in the comments if you haven't already. Perfect. So I'll see you guys over there. I love you all. Have a wonderful weekend. Bye-bye.